Thursday, February 8th. The legislators are just getting ready to gavel down and go home for the weekend through the snow that I can see falling outside my window. So, I think I'll just go down the line of Senate bills and then House bills and give you the update. Senate Bill 87, that's the one that said guns everywhere, including your private property, unless you put a metal detector out in front. That came out of committee, Senate Judiciary, a week ago. 4-3, it died on the floor of the Senate, so that's dead. Senate Bill 111, that was a bill that the bar commissioners said to kill, and that allowed the prevailing party to recover the costs of investigation. That bill is dead. Senate Bill 139, I mentioned that a week ago, that creates a presumption that the parties have agreed to change custody if they've arranged for something different, and that different arrangement lasts for in excess of 120 consecutive days. That's through the Senate and will be heard in House Judiciary, but probably not for a couple weeks. They've got still a ton of House bills that they've got to deal with first. We have that trilogy of bills, Senate Bills 140, 165, and 167. 140 is the bill that would try to increase the degree of parenting time that the non-custodial parent would have, assuming that the non-custodial parent had been active in the life of their child prior to the separation of the parents. That's through the Senate. There's a little wordsmithing going on that's been suggested, and I'm working with the sponsors on that. 165 is another bill coming from fathers with regard to enforcement of visitation. That likewise passed the Senate, and we may need a little bit of work on that one over in House Judish with regard to the form that allows the parent who is aggrieved, that says that they're not getting their full rights. UJS already has up on their website a form. I think it's better. On the other hand, it's not like I care a lot, frankly. So the prime sponsor there is looking at the two forms, and we'll talk about that later. 167, that was the traditional shared parenting bill, and I mentioned last week that by amendment in committee, they've stripped out all the language except about 10 additional factors that the court would consider in trying to do the permanent parenting time distribution. Senate Bill 145, that's that. We're not working that one. That transfers bad faith and work comp away from the court system over to the Department of Labor. That's been assigned to Senate Commerce. Hearing on that bill has not been scheduled, and the State Bar is not taking a position on that, at least not yet. But it is a watch, because if they start doing amendments, that my instructions could change. Senate Bill 171, that provided for taxation of severed minerals, that was killed in committee. Again, not something we're working, but for those that do mineral rights and so forth, it might be of your interest. Senate Bill 172, that's the response to the governor's State of the State address, where in order to encourage migration to South Dakota and to fill in the gaps where we have a shortage of perhaps plumbers, electricians, etc. In response to that bill, there are a number of professions that have asked that they be accepted out. Lawyers didn't participate in 172 because the governor's bill was amended, and it said only those licenses which are issued by the executive branch, and of course we all know that lawyers' licenses come from the Supreme Court. So the legal profession is out. Those professions that are trying to be exempted from the governor's plan are doctors, dentists, chiropractors, optometrists, pharmacists, and architects, I believe. Now let's switch over to some House bills. 1085, unsworn statements. That is through the House. I suspect that they need a little bit of amendment work over on the Senate side. That's one that we're just watching and making sure that it comes out in decent shape. House Bill 1112. That's our bill that came from the Family Law Committee and was approved last year, and that clarifies that the statute of limitations to challenge based on DNA evidence or genetic evidence that that the father is not the real father, and that would not be bound by the 3-year statute of limitations that exists in all other challenges. In 2015, I believe, the legislature enacted the bill that talks about if subsequent evidence comes along, you could challenge that when it clearly shows that you're not the parent. Ergo, why are you paying child support? And so that law wouldn't make any sense if it was still bound by a 3-year statute of limitations. That's a clarification. Came through committee, it's been through the House, and it'll be heard over on the Senate side. House Bill 1139, adverse possession. All that is a form. Section 2 talks in terms of setting up a way to transfer, if you're going to assert successfully adverse possession, that you ought to have to pay the taxes thereafter. There's really nothing in the code that explains that process. This particular bill has been on the floor for several days. It's still held over. I don't know if they'll take it up on Monday, possibly even Tuesday. I suspect that there'll be some movement that says delete Section 2. That would mean that it would simply come down to a form that 2 consenting adjacent landowners could agree that the fence line doesn't reflect the actual property line as between the 2. There was a small amendment offered in committee and approved, which says that nothing in this bill will impede the enforceability of easements or utility lines, and I didn't know that the amendment was necessary. Nevertheless, because they wanted it, we didn't care. House Bill 1202, that's the law school funding bill to provide some supplemental funding to help the law school maintain its proper operation, and to make sure that I think it's a year from now that they come up on accreditation and that we're okay there. That's been assigned to the Joint Appropriation Committee, has not been scheduled for hearing yet. There's no hurry on some of these money issues because they're still waiting on early next week. They'll get the latest projections on where we are financially. Have sales tax revenues bounced back or not from a few months ago? So we'll wait and see. 1245, that's our bill, and that would provide some general funds for the Equal Access to the Court Commission. That has not yet been scheduled. It's been assigned to Joint Appropriations, and so I'm quietly working that one in preparation for a hearing that I anticipate will take place in 7 to 10 days. Back up a little, House Bill 1204, that amends the process for powers of attorney, and that's simply pending right now. It'll get a hearing. House Bill 1208, that was to reduce the maximum for child support for those who are poor from 50% of their monthly income down to 40%. The sponsor withdrew that bill. Likewise, the same sponsor withdrew House Bill 1212, which we required every divorcing parent parents, if they had minor children, they had to prepare and submit a shared parenting plan. That also was withdrawn, so those are dead. That was part of the overall package deal with 140, 165, and 167. Finally, the last bill that I'm keeping an eye on is House Bill 1283, which would allow appeals from small claims. I think that's a constituent bill. Somebody didn't like the result coming out of small claims and then discovered that they had no appeal. As lawyers, you already know that if they want the ability for any appeal, they need to move. They need to timely move to the formal side of small claims, get a jury if you want, and then you have a record. In any event, that's a watch. I don't think it's going to go anywhere, but it's on the watch list. Other than that, that's the update. We have some work to do in the family law area, but the bulk of the work has been done, and after that, it's primarily, hopefully we can find both the money and the willing legislators that will support it for both the law school and for legal services, which is the Equal Access to the Courts Commission. You have a good weekend, and stay warm and shovel the snow.